And he tried...
My question really is, did he do any other transactions that are challenged, or is that it?
Yes, well, no, yes, what he did is this. They've set up their own synagogues in Brooklyn. They've set up their own schools in Brooklyn and yeshivas. And they set up a corporation called the Central Congregation Yetiv Lev to cause confusion. But they have, for 6.5 years, they've had their institutions in Brooklyn. People have a place to pray who support Rabbi Aaron. There's a place for them to go. So they control Kiryas Joel. They control the congregations that they set up in Brooklyn and the schools. But that's not enough. This goes back to 1999, that they can't accept the fact that the father, the Grand Rebbe, chose the younger brother, Zalman, to head Williamsburg. And they tried to say, in each case, they went before Justice Leventhal in Brooklyn and tried to they started a guardianship proceeding. Every judge who was taken, with the exception of Justice Rosenwasser, almost every judge who's taken a look at this, and I'll exclude the dissenting justice in the appellate division, has said, you can't look at the labels. You can't. They're trying to present disputes as isolated matters. In London, in the Washington Post, the CNN, the New York Times, the New York Law Journal, everyone has recognized this is a part and parcel of an overall fundamental fight for the ecclesiastical leadership of the congregation. The bylaws are not limited to ecclesiastical issues.
Of the congregation or of the Williamsburg?
Of the congregation in Williamsburg, which happens to be the seat of the worldwide Satmar movement, and we have our supporters all around.
But it doesn't also take in Kiryas Joel?
It's separate corporations, and at one point, in fact, in their papers, they say, oh, it's one congregation, we all voted together, it's one congregation. If it's one congregation, how does that fly? Doesn't that fly in the face of their saying they're separate boards? When it came time to the cemetery, it's a separate corporation. We're not able financially to handle the expenses of the much bigger congregation. So what we're saying, I have a petrified congregation that says somebody's going to say there's an irregularity, and I just want to make this point.
But they say, I think they admit they're two corporate entities, but they say the Kiryas Joel people are members of your congregation. I gather you dispute that.
Oh, there's no question of that, because our bylaws...
Who's supposed to decide that question?
According to the Supreme Court and according to your court, if it's a question of membership that turns on ecclesiastical issues, if the membership requirement said live in Brooklyn, pay $50, neutral principles, this court could do it. When it says you will observe Torah, you will observe the Sabbath, you will observe the teaching of our forefathers, you will live your life in compliance with the Code of Jewish Law, a 16th century multi-volume treatise that's been studied for hundreds of years, and the Supreme Court has said...
My question was about the very narrow issue of whether the Kiryas Joel members are members in Brooklyn. Isn't that a secular question a court could decide?
No, because you can't be a member. You can't decide whether somebody's a member without determining, did the Grand Rebbe have the power? The bylaws only, the provision they pointed to, by the way, gave certain grounds to remove somebody as a member of the board. There's a difference between being removed by the board and being removed by the Grand Rebbe. They admitted, Yossi Brock testified in court before Justice Barish when he was asked the question, if the Grand Rebbe says somebody is out, are they out? Yossi Brock testified, yes. Aaron, in Kiryas Joel, there was conflict when he became the chief rabbi in Kiryas Joel. And some people resented him and didn't like him, and they started a rebellion in Kiryas Joel. And that's when, in 1990, he put in an affirmation. And he said, in his affirmation, you must obey the rulings of the Grand Rebbe and the rabbis he has delegated. And he asserted the culture of the Satmar community and explained it. And he did it to perpetuate his own position. Now, all of a sudden, well, the Grand Rebbe only had limited powers. Oh, it depends, whether the papers went out. That wasn't true when he was perpetuating his own position.
Thank you, Mr. Mueller.
Thank you.
Mr. Novak?
Where does membership have anything to do with whether this declaration was authorized?
I think he was answering a question from the bench.
I'm sorry. First off, in the record, at page A2176, 2177, is an affirmation stating there is no rabbinical court. They do not conduct arbitrations. The bylaws, page A208 of the record, Article 10, talks about members being expelled. It states, a member may be expelled after certain procedures. A three-person committee has to investigate the allegation. They have to report back to the board. The board then makes a final determination after these steps are followed, whether to expel or not. And by the way, if the January 18th meeting was not a valid board meeting because there were only 11 people there, only 11 board members, they could not expel, even if you had satisfied the other threshold requirements of an investigation and a report by a three-member committee appointed by the board. But in subdivision C, subdivision B of that says a member must be expelled, quote, if he declines to submit to a din Torah, rabbinical court proceeding in parenthesis, or to comply with the psak, parenthesis, ruling. It doesn't establish a court.
I thought there was no court.
There is no court. Mr. Mullen was saying that there are judges who are in the congregation who constitute a court who have the power to render arbitral rulings. If he is saying something different, and he's saying, no, it's not an agreement to arbitrate because there is no agreement to arbitrate, he is then saying that, similar to what was said in Jones v. Wolfe, First Presbyterian, the hierarchical authority, you can analogize the Grand Rabbi to it, the hierarchical authority has said this, you can't challenge that, a court can't get involved. It's a perfect circle. If whenever we want to enforce a secular right that's laid out, which the Jones v. Wolfe says New York can adopt and New York did adopt, the answer is going to be, no, you can't, because under religious doctrine, the Grand Rabbi has the right to do whatever he wants.
Where are the limits, though? I mean, at some point, these proceedings to expel people are obviously going to get into question whether they observe the Torah. You don't say that the civil courts can review that, do you?
No, I don't. What I do say is, if there's a bylaw procedure set out that vests in the board the authority to expel from a secular corporation a member of that corporation, I'm not talking about an unincorporated group of people, that procedure is laid out in the bylaws. That's secular. That's Jones v. Wolfe.
And would they have the authority to expel that person on the ground that he was an infidel?
If the procedures were followed, I would think that you would have authority if there's an ecclesiastical judgment that is made further down the line, if you followed the authority set out in the bylaws, and if, we're talking about the corporation now, and if the bylaws specify this is a ground for expulsion. Again, there was I believe it was the Westminster case, which is cited at page 131 of their brief. I think there was a wholesale attempt to dissolve a local church, and then the hierarchical church said, well, since there's no more members, we're taking over. And the Court of Appeals said, you, the spiritual, can't dissolve the secular. They recognized the distinction between it. It was either Bolden against Alexander, or I think it's Westminster. I'm doing this from memory. So my point is that you are being faced with the broad, besides all the factual arguments, I could be at trial listening to all these factual allegations which we dispute, and I just want to be clear, we're disputing them. You are faced with the broad argument that you can't look at the secular principles here because I'm telling you this is doctrine. Now, it's undisputed in this record that we have a very different view of doctrine. The appellants deny that there is any such authority that is secular. Indeed, when the Grand Rabbi supposedly talked about expelling Beryl Friedman on his January 18th speech, he said, by virtue of my supreme authority in spiritual matters. And finally, the Grand Rabbi has never taken this position. No one in the congregation before this case has ever taken the position that this is something that the Grand Rabbi has authority over. We cite in our brief, this is a newly announced doctrine. Indeed, in court, Mr. Mullen said, we invite the court to decide the validity of our election. This whole cloud about non-justiciability has come up because of Justice Parrish.
Do you dispute that at all times the de facto management of the Brooklyn congregation has been in their hands? They've been writing the checks, they've been cleaning the walls, whatever it is?
As we explained in the brief, in January 2001, some of the people who are in the offices are aligned with the respondents. What happened then, there was what we have called a little mini coup. Those offices were completely taken over by respondents' representatives. And immediately thereafter, the appellants went to a Beth Din to seek to have an arbitration on that issue to get it back. However, the respondents refused to go to the Beth Din, and it's voluntary.
My question really is just the people who are actually showing up in the office every day as their people.
The three people that were, let me just correct a misimpression, a very large misimpression. No judge in the court below ever affirmatively said, or in the appellate division, ever said that the respondents are the elected members of the
Okay, but
congregation.
that really wasn't my question. It is the fact that the people running the organization are their people.
Yes, I think generally speaking that is correct.
And have the Curious Joel people been kept out?
Kept out of the cemetery?
Yes.
I'm not aware of that, Your Honor. I don't think there's any evidence in the record that the Curious Joel people, if they have this title, would do anything to...
No, that was not my question. My question is, during the years that they have had maintenance, control, whatever operation of the cemetery, have the Curious Joel people ever been kept out?
I don't know of any evidence in the record.
I didn't see any evidence.
No, I don't know of any evidence in the record, Your Honor.
Thank you.
You're welcome.